Today I'll be talking about if and when to get a temporary protective order. Now, why am I specifically talking about TPOs? I've had an extensive experience both prosecuting and defending TPOs, which began actually during my law school career with the Jane W. Wilson Family Justice Clinic. I did a full year there, fall of 2022 to spring of 2023. And that's also where I got my first family law experiences, as we would help clients get TPOs, but also would manage divorces without assets or children. So that's why I really crafted my passion for family law. During my time with the Manili firm, I've both defended and prosecuted TPOs. So I've represented both respondents and petitioners in the Superior Court, mainly here in Cobb County. So I've had the pleasure of getting to know judges in that court and kind of have a feel for how the outcome of a case. And also, I wanted to talk about today of how TPOs can complicate divorce cases because a lot of people think that TPOs just influence the petitioner or the respondent and their relationship. But really, it can also get into child custody issues, use of the marital residence, and child support issues. So before we get too far ahead, what is a temporary protective order? And you'll hear me refer to it both as a temporary protective order and a TPO. Some people call them restraining orders. That's how it's commonly more known in the media. But what is this device that is issued by a superior court? In layman's terms, it's a civil order from a superior court judge that enjoins the behavior of the respondent after a finding of fact that the respondent has committed certain acts prohibited by Georgia law against the petitioner. Now, how is this enforced? Because it's a civil order, not a criminal order. It's actually enforced by law enforcement in every county within the state of Georgia. So that does get a little bit complicated, and I'll touch on this a little bit later if one of the parties is out of state. Typically, the way that TPOs work is that it is only enforced within the state of where you receive the TPO. And as far as enforcement goes, if one of the parties violates the TPO, for example, coming closer than within 500 yards of the other party, that petitioner can then call their local law enforcement no matter what county they're in. They could have gotten their TPO in Cobb County, but they might be in Borough County, and it'll still be enforced by local law enforcement to intervene. Now, there are different types of protective orders that are relevant to family law. There's actually a third type of protective order that concerns employees' rights. And just to narrow the focus of today's presentation, I'm only going into mainly family violence protective orders, but also I did want to touch briefly on stalking protective orders. Because stalking protective orders are a lot more expansive than family violence protective orders because it also covers people with whom you don't necessarily have a past relationship with. But a person commits the offense of stalking when he or she follows, places under surveillance, or contacts another person at or about a place or places without the consent of the other person for the purpose of harassing and intimidating the other person. Now, in my experience, stalking protective orders are a lot more difficult to obtain than family violence protective orders. And that is because with the internet and how that's affected our ways of communication, simply creating, for example, a burner account and contacting a person is not considered stalking under Georgia law. There's still a lot of nuance to this area of law with how technology works and also educating the court on, for example, IP addresses and how you can ensure that this is the person who's stalking and it's repeated offenses. But the likelihood of getting a stalking protective order is far less likely than a family violence protective order. You can incorporate stalking into a family violence protective order to show that that's the behavior that's covered under it. But typically, stalking protective orders are very difficult to get. It sometimes it does involve cyber stalking, which is repeated harassment online. And if you can identify that person, and it's for the purpose of harassing and intimidating the other person. But typically, when I raise that argument before judges, they'll ask, did the person change their phone number? Did they try to move? Have they tried to take any other recourse besides coming to the court today for a protective order? So, and for clients, that really disrupts their lives if they have to change their cell phone number. A lot of people had the same cell phone number sometimes since high school. So they have to go through and uproot their connections for a stalking protective order. But sometimes that's necessary to get the relief that they need. But today I will mainly focus on family violence protective orders. So family violence is defined under OCGA section 1913(1). And what's important to note here is the existing relationship that qualifies as family violence. So it qualifies as past or present spouses, persons who are parents of the same child, parents and children, step-parents and stepchildren, foster parents and foster children, or other persons living or formerly living in the same household. So this is an expansive um, definition of relationships covered here because you have foster parents and foster children. But for example, it doesn't explicitly cover like grandparent, grandchildren unless they're living in the same household, or cousins. So you have to have that qualifying relationship first in order to seek out a TPO. Because if you get before, and I'll get into this in greater detail, the ex parte hearing, and the judge asks, what is the relationship? And you say, we're cousins, we're friends. That does not qualify as a qualifying relationship under the statute. And then what's essential for the second part of the statute is what is an act of family violence? And so first, you have the very wide definition of any felony. And so this is usually pretty expansive. For example, a lot of clients will come to me and say, he threatened my life, he waved a gun at me. So that would be considered a felony under terroristic threats. But in certain counties, they will not consider it a terroristic threat unless their testimony is corroborated by other evidence. For example, a police report, there was another witness who witnessed the attacker saying that they were going to kill them. And it has to be immediate for terroristic threats. It can't be, if you do this, I'll do this. It has to explicitly threaten your life in that moment. And then the other types of offenses that are defined as family violence include battery, simple assault, stalking, like we talked about before, criminal damage to property, unlawful restraint, or criminal trespass. And I would like to get into criminal damage to property because a lot of people think that they can't get a TPO because they were not physically harmed, in the sense that they were not slapped by this person. They did not have an intense physical altercation, but there could be property damage that was damaged in front of them. Like they could have thrown a plate at the wall that was in close proximity to them, and that would qualify as criminal damage to property. Criminal trespass is also encapsulated in that. And simple assault, a lot of people, it's confusing because you hear assault and battery, and a lot of people mix up what each of them means. But assault is just the physical apprehension that someone is going to hurt you. They don't actually have to make contact with you. But if someone raises something at you and you apprehend that they're going to hurt you, that would qualify as simple assault. And then the final part of the statute is that the term family violence shall not be deemed to include reasonable discipline administered by a parent to a child in the form of corporal punishment, restraint, or detention. And that's important to note when I'm also defending TPOs. Reasonable discipline to a child, depending on their age and maturity, is not considered family violence. And that's an important distinction. In order to actually get a family violence TPO, there are 3 things you have to prove, which is called the burden of proof. One, you have to show that an act of family violence has already occurred, which means that that statute that we just went through, that there was a qualifying family relationship, and also that there was an act committed that is covered under the family violence statute. Second, you need probable cause to show that future acts of family violence will occur. And this is a more difficult burden of proof because you're essentially having to show the judge that there's a pattern of behavior that puts the petitioner's life at risk. This can be difficult for clients who have only had one violent encounter with their abusers, but sometimes the severity of the encounter can show the pattern that it's likely to happen again because it was so severe. Another thing that you can show probable cause that it will happen again in the future is if there was a buildup leading to the violent act. Like there were text messages showing, I'm going to do this, I'm going to do that, and then the person actually does it. That can help show that a future act will occur. And finally, you have to show that there's no other present relief available to the survivor. What that means is that when you file for divorce, um, especially in Cobb County, we see this happening a lot. There is an automatic standing order that is in place that specifically states that you are not to harass the other party. So typically, if the only act of family violence that's occurred is terroristic threats, then a judge may be hesitant and say, look, you have already filed for divorce. The standing order protects you. Another form of relief that can be present to survivors is if the person was arrested and is out on bond, because typically those bond conditions will state that they are not to come within a certain number of yards of you, they're not to come to your property, and they're not to contact you, or they could face charges of aggravated stalking, which is a felony. So what does a TPO actually do? The range of a TPO is actually very vast. The judges have a lot of authority and discretion with what they decide a TPO will actually enforce. Typically, it's the civil order from the court with criminal consequences for the respondent, included the charge of aggravated stalking. And that's to say that if they violate the TPO in any way, for example, if they have a firearm where they're not supposed to, if they're within less than 500 yards near you, they will be charged with aggravated stalking if you report them to the police, which has serious criminal consequences. Typically, every TPO prohibits some kind of harassment, contact, and intimidation between the parties. They prevent intrusion on property. And this can also be a touchy subject because in certain instances, the survivor has decided to move away from the perpetrator, and they still want their address to be considered private. And the court does allow flexibility that you could limit it to a zip code, you could limit it to a neighborhood without giving your specific address for intrusion on that property. It prevents respondents from possessing a firearm. And this can be a tool that can help settle TPOs before they go to a hearing, because a lot of the times respondents have an issue because typically the restraint from possessing a firearm is a deal breaker for them. And so they will settle on every other ground of the TPO before it's heard before a judge in order to keep their firearms, because typically TPOs last at least 6 months. Most of them are for a year. And so sometimes respondents say, you know what, I don't want my gun taken away from me for a year. I will settle on every other ground. So that can be used as a good negotiating tool before you get to court. And there's also flexible relief from the court, including exclusive use and possession of the marital residence. And this is from one of the family violence statutes of the broad discretion that the judge can have when granting a TPO. And I did want to draw y'all's attention to certain provisions, because a lot of people think, like I said earlier, that child custody is off the table. Child support is not something that the judge can grant during that hearing, but actually you can calculate child support. It's best to have a child support worksheet already prepared using the respondent's salary, and also have a parenting plan available if you would like to visit limit supervised visitation, or if you would like to have supervised visitation versus unsupervised visitation between the respondent and your children. It also can require the return of personal property of to each of the parties. And typically, this is done by law enforcement. They get a one-time visit back to the marital residence, accompanied by law enforcement to ensure that both parties are safe. And it's usually when the petitioner is not in the home. And another form of relief that clients don't typically think about is the award of costs and attorney's fees to either party. Typically, this is in the case when I'm representing a respondent and the TPO is completely unfounded. And so the prevailing party will actually get attorney's fees from that. And that's another thing on both sides of the table when I'm representing a petitioner as well. Because if I don't think that there's enough evidence to show a TPO, and I think the standing order from the divorce is enough to protect them, filing a TPO and going to a TPO hearing risks my client having to pay the respondent for their attorney's fees if we don't prevail. So that's part of how we at the Manealy firm are very strategic with advising our clients about TPOs. Now, how do we get to actually receiving a TPO? The first thing is an initial screening in the Superior Court or through a victims advocacy agency. Um, every Superior Court I've been to file a TPO on behalf of one of my clients has different rules for this initial screening. Sometimes there's a person in front of you that will go with the screening. Sometimes you are given an iPad and just tap what acts of violence you purport have happened with a general description. And that Superior Court will then evaluate whether or not you have enough evidence for an ex parte hearing. So that is just kind of the first baseline that you need to get to. I would say when you're preparing for the initial screening, make sure to have an abbreviated version of what violence has occurred, and make sure to have the dates already ready because timing is essential for these things. For Cobb County, they only have TPOs open at 11 and 1. And so you have to get there before 11 and before 1 o'clock to be able to go to that ex parte hearing on the same day. So I definitely don't want to waste my client's time preparing them for a TPO and then find out, oh, we've missed the first hearing. We have to wait for the next day, especially if there's a present danger to them. So we have the initial screening, and usually on the same day, we will have the ex parte hearing. So what does ex parte mean? Ex parte is a legal term meaning that one party is before the judge for an issue. And so it may seem like it's just going to be the judge and us talking, but actually a lot of people will have other appointments that same day. They'll be usually the office is packed from all the initial screening they do because they do it in groups. So I will go, if I'm representing my client at that stage, I will go with them to the podium and explain to the judge why we're asking for the ex parte hearing and the ex parte petition to be accepted by the court. And I've seen it go both ways. Sometimes it is more advantageous to go pro se than having an attorney at that stage, just because if there's a divorce already in place, sometimes the judge will get upset with attorneys saying, why are we doing this? This is, you need to file for divorce first. You need to do this, this, and that first. You have to have another custody order. But I can also advise my client to go pro se and essentially provide them with advice of how to present their argument to the court to get the ex parte petition approved. And then if at the ex parte order, the petition is approved, then there is a 30-day order from the court that protects my client from the respondent. And so as soon as that is signed, the sheriff's office will go and serve the respondent with that paperwork. And typically it means that if they're both living in the marital residence under the umbrella of family law, the respondent will have to leave the residence immediately. They'll have 10 minutes to gather their things, and they'll be accompanied by law enforcement to exit the residence to ensure that the petitioner is protected during that time. So that will last 30 days. Typically, an ex parte will also protect the petitioner's children from the respondent, as well as the petitioner's associates, friends, and family during that 30-day um, time period. And so during those 30 days, I've had clients come to me at different stages where it's like they just had the ex parte, or sometimes a few days before the 30-day hearing. For me, the best time is for me to be with them during that initial screening. So I can be with them from start to finish and ensure everything runs smoothly, that their thoughts are organized, that we've gone through every avenue to try to get evidence for the big 30-day hearing. Because the 30-day hearing essentially means that it's the final decision as to whether a TPO will be enforced for 12 months or not, or if it will be denied. And the only protection they've had is for the 30 days we previously had. And then the next step, if you are awarded a TPO, is after that after that 1 year, you can go back to the court for a permanent restraining order, and choose between 3 years to extend that order or making it a permanent order. This is a very high burden of proof, because you have to show that there is a reason to continue this TPO indefinitely, which is very hard because it's hard to show that the TPO has been working. Because how could somebody commit an act of violence except by just straight up violating the TPO during that time if they're prohibited? So, of course, the TPO hasn't been violated. It shows that it's working. But if there's a lapse in the TPO, we have to show the court why they are still fearful a year after it's happened. And this can be very difficult if the respondent hasn't violated the TPO in that time. It's also important to note that when it comes to filing, you have to, as the petitioner, file where the respondent resides, um, which can be an inconvenience for a lot of petitioners because it might be a situation where their ex's ex-boyfriend, ex-girlfriend, but they still share the same children and try to co-parent, but they live in different counties. The only exception for the for jurisdiction, which means where the actual hearing will take place, is if the respondent resides out of state. Then it can be where the act of family violence occurred. So when do you actually need a TPO? And this is typically something, if you choose to retain with us for a TPO, I would go over with you during your strategy session. So the first thing that I would likely ask is, when did you suffer the act of violence? Because timing for TPOs is one of the most crucial things to be successful. The best situation is when it happened the weekend before, you come to us on a Monday. You called the police, you're gathering evidence. But it's very difficult to show, for example, you were abused by your ex 6 months ago, and then you get a text from him today saying that he's going to do the same thing again. A lot of judges are hesitant to enforce a TPO when there's been a 6 month period where nothing happened. And so I always believe my clients. I understand their fear, but sometimes that is hard to prove to a judge, showing that, well, if in 6 months nothing happened, and if he lives in another county now, how can that, how can you show that he or she is fearful of the respondent? So immediacy is always important. Does it fall under the statute's definition of family violence? For example, going back to terroristic threats, saying, oh, I wish I could kill you. That is not a terroristic threat. There has to be immediacy that says, if you come by this house, I'm going to kill you today, type of thing. It also has to be within the definition of the relationship. So what's interesting is that if you were in the same household, that does not necessarily mean you were blood related. So it's very expansive there. But if, for example, you are getting a TPO against your grandson, that does not automatically fall under the qualifying relationship that is essential to the statute. And then next, what proof do I have? The worst thing is when I get to the 30-day hearing and I've been working with my client, and the only evidence we still have is that she just has her testimony to say what happened, because that's what the ex parte hearing is for. At the ex parte hearing, we usually aren't able to show any kinds of evidence outside of just testimony. So for the 30 days, I'm working on trying to find police reports, if there's been any other instances where the respondent has done this to another person, if there are any active warrants. We do a full criminal background check. In some cases where it's very severe, we might hire a private investigator to accumulate more evidence. Um, Also, great evidence is that there's proof that the respondent has continued to violate the 30-day order. For example, you're still getting text messages from them. What I see happen a lot is that they will often contact the parents of the survivor or try to get their friends, leave them notes, that kind of thing. And typically, when there's clear violations of the TPO like that, judges are very quick to enforce a TPO because they're saying, hey, if they're not respecting this 30-day order, which is so temporary, then we need a year-long order where the consequences are aggravated stalking so that there's immediate relief for this person. And again, going over what is the relationship between myself and the other person. And I included this to also consider what would the long-term effects be if you get a TPO? Because sometimes, again, it's not strategic to get a TPO if you know you're going to be co-parenting with this person for a long time and it was an isolated incident of violence. It's always important when filing for divorce or filing for custody to think of how is this going to affect myself, my children, the other person, far beyond after the 12 months are over. And again, going back to the ex parte hearing, we want to make sure the judge knows the qualifying relationship, the instances, and the necessity of the TPO, which I like to call your why. The worst thing that you can do, one of the worst things you can do at an ex parte hearing is say, I want this TPO because I want the other person out of my house. Because there is unfortunately some sort of a stigma with TPOs where a lot of people think that they are used to get the other person out of the house, and that's the only thing to try to get a leg up in the divorce. And unfortunately, it does happen where people do abuse the system and try to use it as a leg up for a divorce and say, I've been living in the house, therefore, I should have exclusive use of the residence until the divorce is finalized. And also, this shows through equitable division of the assets that I am entitled to over 60% of the equity in the house, for example, instead of 50-50. It's good to enunciate why you are fearful of the other person. And that's where it goes to the strategy of why do I think that this incident of violence is going to happen again? And so at the 30-day hearing, there's a higher burden of proof than the ex parte because it's not just did it happen, it's how can we show that it will happen again? So a year-long order from the court is necessary by preponderance of the evidence. Next, over those 30 days, again, I will be working on physical evidence, witness testimony, and working with my clients. I typically like to have a hearing preparation meeting with them in order to fully equip them emotionally and mentally for what it's like for the 30-day hearing. Because a lot of people think that TPOs are a private matter because it's civil, but that is not the case. Usually TPO dockets are full, it's a full courtroom. You're going to have to get in front of a lot of people and share what might be the worst day of your life. And I want to fully prepare my clients mentally, emotionally for having to get up there and do that. The other thing that I have to prepare my clients for is being subject to cross-examination from the respondent or the respondent's attorney. Now, a lot of the time, because it's a 30-day hearing, there's such a quick turnaround. The respondent will be what's called pro se, which means they represent themselves and they don't have an attorney. And typically in these cases, I have to prepare my client even more emotionally for what could happen because an attorney knows the rules of evidence and knows not to harass um, the person who is testifying pursuant to the rules of evidence, attorney ethical code, um, so many other things that they're subject to. While a pro se person is not subject to any of those things, of course, the judge can intervene and let them know that they're not allowed to go down that line of questioning. And I, of course, will object if the questions become harassing. But just the trauma that can happen of your abuser asking you incredibly intimate questions on the stand can be re-traumatizing for that person. And so I try to get my clients as prepared as possible to be ready for that moment. And I want them to know that I have their back. I'm going to object. I'm going to also subject the respondent to cross-examination. And so that gives them a little bit more of a fair fight. But also sometimes with respondents' attorneys, I've had them ask harassing questions. Um, Sometimes TPO matters can like it can be 30 minutes, it can be 2 hours. So sometimes it's an endurance test, emotionally and physically, and I want to make sure my clients are fully prepared for that. So the biggest takeaway with TPOs is do not wait. Um, it is incredibly crucial to contact an attorney if you feel like you cannot handle the initial screening or the ex parte by yourself. Um, it might just be best. I always encourage my clients to get help from the very beginning. And again, the biggest issues with TPO is the delay in contacting police. I've seen it time again that even the next morning is not fast enough to contact the police once a family violence incident has occurred. You need to get them on the phone as soon as an event has happened and make sure you enunciate what happened and why you're scared for your safety. Um, the worst is that there's not even a police report of what happened. And this can be for a lot of reasons. Again, we as attorneys are incredibly trauma informed, and we know that sometimes you have fight, flight, or freeze, and sometimes people freeze and they don't contact the police. But the best thing is to contact the police as soon as you can once an incident of family violence has occurred. The second mistake is delaying filing the petition. If you wait, for example, even 2 weeks can be too long in filing a petition, and it can get denied even at the ex parte stage if there's been that kind of time lapse. 6 months, at that point, it's nearly impossible unless there's been a very real threat that's accompanied it. And a year, I have, in my experience, never seen a ex parte be granted after a year in between violence without some other circumstantial evidence showing that the violence is to occur again. And again, on the flip side of that, because a lot of the time there will be respondents who are actually being persecuted by the petitioner. For example, they've told the petitioner, I'm leaving, and they're actually the survivor or the victim in this situation, saying that they're going to file a TPO, but then the perpetrator files a TPO before them. And so that's another thing, is that do not talk about the TPO with anybody else except your attorney. And then there is also a possible delay and a counterclaim. And this would also go to the instance where you have a respondent who wants to counterclaim and say that they are actually the victim of abuse rather than the perpetrator. You have to do this at least 3 calendar days before the 30-day hearing, and that does not include weekends. So if you have a hearing on Monday, you need to get that filed well Tuesday, Wednesday, make sure that it's with the court, or else you cannot raise a counterclaim defense at your hearing. And finally, the biggest delay is in hiring an attorney. There are certain stages where I've seen clients be successful in essentially representing themselves, such as the screening and the ex parte. But for that 30-day hearing, I cannot suggest enough in hiring an attorney, especially if the respondent has hired an attorney. We are here for your phone calls, like even the day before hearing. Not ideal, but we are here and we have a strategy to help you and we will do our best to make sure that you're able to prevail in that case. So I just wanted to thank y'all for your attention during this presentation. TPOs are one of my passions for family law, and it was, the way I first got started doing it. I've presented my contact information. If you or someone you know needs help with a TPO, please contact us and don't wait before it's too late.
All right, Caitlin, thank you so much. That was very thorough and very informative. This is the time when I'd like to invite our participants to ask some questions. And then while they're gathering their thoughts and getting some questions together for us, I have some as well. And so you mentioned that, an act of family violence could be property damage, someone throwing a plate, in your vicinity and it busting or being broken. What I guess if there is grabbing and twisting someone's arm and wrenching keys out of their hand, maybe there are no bruises. Is that, an act of family violence? And is that in and of itself enough to prompt one to get a TPO, or would it kind of fail in terms of not showing a pattern of family violence? And then if you can kind of, from your experience, describe, kind of the range of acts that where there's been success or where a judge has denied. Then I have a follow-up.
Sure. So I can go into addressing the incident where someone's trying to get keys from another person and they wrench it out of their hands. So that would actually be three types of family violence right there. You have a simple assault if the person can see that person walking towards them with their hand prepared to grab the keys out of their hand. You have battery, which is an unwanted touching with no consent, which would be the actual wrenching of the keys out of their hands. And finally, for the keys itself and preventing them to, like, for example, their car keys, their room keys, that could be an argument for false imprisonment, which is a felony. So you could also say that that is preventing them from exiting the home. So I think that is more than enough to at least get to the ex parte stage. What's difficult is, for example, if this happens in a hotel room and there's no other witnesses. Um, Typically, if you're in a house with other kids, the children can come see, but that also creates difficulties because you get into child hearsay. And I particularly strategically would never put a child on the stand unless it's absolutely necessary. But when you have no witnesses, that's when you really need to afterwards call the police so that you start developing evidence at that stage. And then going into what qualifies as family violence that a lot of people don't think of. I've seen cases where somebody's thrown objects at a person's house and broken windows. That again would be criminal trespass because even though that person is not physically going on their property, they're throwing an object that was originally in their possession. It goes through the window, and that's trespass. So that's another thing that people don't commonly think of.
Very good, thank you. And now I don't have a follow-up because I was actually going to ask about false imprisonment. And so you took care of that in your response. I do have some questions. One of our attendees asks, how about a criminal TPO? Do they have similar standards? How about the time period? Is it still 6 months? And so this is a great opportunity to discuss, if someone gets a TPO order against them, do they have a criminal record? So if you'd elaborate on that a little bit in the distinctions or commonalities, or is it all the same?
Question. And a lot of times when I'm representing respondents, because here we represent respondents, petitioners will take TPO cases on both sides. And so typically with a respondent, the biggest thing is, am I going to be put on a registry? Is this going to affect my job? Is this going to ruin my life, basically? And TPOs are civil cases. meaning that it's not going to affect your criminal record unless you break that TPO. So that means contacting somebody after the TPO has already been initiated by the court. Again, as far as time between the 6 months and 12 months, judges have discretion. Typically, if they think that the relationship isn't going to last very long, for example, if their ex is just boyfriend and girlfriend and they don't have any children, that's a situation where they would have 6 months rather than a year to kind of have a cool off period. But there are only criminal consequences for that person if they violate the TPO. Now, they are registered in a domestic violence registry, um, and that is typically completely private. It's only accessible to judges, courts, law enforcement. For those instances where, for example, y'all are both at the same grocery store because y'all live in the same county. It is the respondent's duty to leave first if y'all are at the same grocery store. It's not the petitioner's duty. But also, the petitioner is not to essentially force the respondent out by getting closer and closer and approaching them, because that's also showing that they're not fearful of that person. So if you, as the petitioner, you have 2 options. You yourself can leave if you're incredibly uncomfortable that they're there. Absolutely. I know it's an inconvenience, but if your safety isn't on the line, absolutely leave. Or you can go to the store manager, ask to speak to the police, and go to an area of the store that's more enclosed so the police can come and you can feel safer. But again, it's typically just better to leave, especially if the respondent isn't aware that you're at that grocery store and it's a simple mistake, simple coincidence. Because again, if you're calling the police for a violation of the TPO, it needs to be a pure violation because again, that could affect your ability to get a permanent TPO later down the line.
Another question that we have is, and you did mention that we represent both petitioners and respondents in TPOs. How do you respond when you're being accused of domestic violence and there's, when the motivation is just to harass and upset you and to damage your reputation? Is there a way for one to protect themselves when they're in that situation?
Yes, absolutely. And that's what I'd like to bring to the forefront as well, is that it's terrible that TPOs are abused a lot of the time. Not 100% of the time, probably not a majority of the time, but it happens so frequently that a lot of people lose credibility for the people who actually need TPOs and protection from the court. So if it's a baseless TPO and you're trying to defend yourself, the best thing to do is to gather contradictory evidence. For example, in the police report, they have inconsistent stories of what happened, or you have another witness who knows that you were not at the house at that time. Poke holes in the story as much as you can. The other thing is to make sure to file your counterclaim, especially if there's mutual combat, which is when the petitioner has actually been aggressive towards the respondent. Because a judge will typically not enforce TPO if there's signs of mutual combat where it's a equally abusive relationship, where both parties are being physical with each other. What they can do is also have a settlement agreement, which if my client as a respondent has in fact committed acts of family violence and understands that his best day in court is settling rather than going through a full hearing, I can draft a settlement agreement that's going to be a lot lighter than what they'd get in court. So we're prepared to represent people on both sides of the aisle, petitioners, respondents. Each case is different, but there are plenty of ways to defend yourself if you've been served with a TPO.
Let me ask, when you say I can draft a settlement agreement that's a lot lighter than what they would get in court, what are the consequences? Are we talking, and I think you talked about this a little bit in terms of having to bear attorney's fees, but are there fines? Is there, time served? Or are we talking about the amount of time you'll stay away from each other, the distance that you'll stay away from each other? Can you describe, what a lighter agreement is compared to what a court might do?
Absolutely. So the biggest thing that I see this in is when it comes down to when children are involved. A lot of the time, the petitioner will either want no visitation if the respondent and the petitioner share children. And so when they're on that side of the aisle, what I can say is, okay, let's have supervised visitation and let's have a mutual family member act as the neutral to supervise so that the children aren't thinking, "Why am I at a police station where mom drops me off, dad picks me up?" Causes a lot of trauma for the children. Sometimes courts can appoint a neutral third party, but that adds another stranger into the mix of why is there a stranger every time I'm talking to mom or dad? And so in that situation, you're really tossing a coin before the judge for whether or not you're going to get supervised visitation, unsupervised visitation, or no visitation at all. So sometimes, if, for example, your bargaining chip is giving the other party exclusive use of the marital home, then you're still going to be able to see your kids for that time because 12 months is a long time. And I don't want to, we are not the firm that just will go to court just to go to court. We are very strategic. And so a lot of people will say, well, I don't want to settle. I want to have my day in court. But are you really willing to risk not seeing your children for 10, 12 months because you want to have your day in court per se? So we are very strategic with that. And I've had settlement agreements actually work out. And it benefits the children, long-term goals, and honestly, both of the parties.
Are there other options other than a TPO? Is there something called a restraining order? Is there something out of magistrate court? What are some of the other options, or are there other options?
Yes, so there are other options. Again, if you want a divorce, having that standing order is automatic in Cobb County, which prevents harassment or removing the assets from the jurisdiction of the court if you're worried about the sale of the marital residence. Another option, which I think is done through magistrate court, is a criminal trespass protection, which means that the perpetrator is not allowed to come to your property. So if it's a matter of harassment where they just keep driving by your house, you can have that, and that has criminal consequences. But a restraining order really is the same thing as a TPO. They're interchangeable. It depends on the state. Some states refer to them as restraining orders, but it's essentially the same thing.
Now, we do have another question, and it may not be this person qualifies limited to domestic violence settlement. If a party offers a reasonable settlement and the other party rejects it, could this be used against the other party to get attorney's fees since they weren't willing to, resolve it through a settlement agreement?
Yes, so I've actually had an experience with that. Typically, negotiations are not able to be brought up to the court. It's a rule of evidence that you cannot bring that up later because the whole purpose of negotiations is that you're negotiating in good faith. And so you would not be able to negotiate in good faith if you knew on the other side of it, hey, this person's going to turn to the court and say, well, I offered them $40,000, $50,000, $60,000 from this divorce action, and they still turned their nose up to that offer. What I have seen happen though is that later, if there's a divorce action, they can ask for that in attorney's fees. Um, and that kind of flips negotiations, which is it shouldn't be allowed because under the rules of evidence, you cannot bring up past negotiations as leverage. However, I've seen it happen, unfortunately. So sometimes, especially offering a monetary amount in settlement or offering attorney's fees is not the way to go. It's more about what can I work with visitation? What can I work with the exclusive use of the marital residence? Um, who, if I say that I won't contact anybody that they know, is that a bargaining tool? So we try to steer away from using money as a negotiating tool in TPO as much as possible because it can come back as fees.
So we do have time for one final question. What happens when a person may respect the TPO against the petitioner, but they shift their attention toward other family members. Uh, or, and of course, I guess a TPO would or wouldn't apply because they haven't lived in the home together, but yet kind of the behavior is attached to the individual with whom they did live in the home, with. I guess, does the TPO cover that, or does a subsequent action have to occur?
Right. And again, we see this a lot with child custody, but in terms of an adult, like for example, let's say, excuse me, the brother of the petitioner used to be friends with the respondent, and he's saying, "Hey, buddy, can you get her to talk to me?" And if he's included no contact with friends, family, or associates, then what the brother needs to do is inform his sister, saying, "Hey, blah blah, talk to me. I do not want him talking to me. We need to get this resolved." Then your option is to call the police and let them know that he's violated the TPO. Again, if you and the respondent share children together and you're receiving child support, then it may not be strategic to call the police at that point because he cannot earn a living from jail. So that's another thing you need to think three steps ahead of the other person is that yes, this TPO is in place, but if you are receiving alimony, child support from them, then it might not be the best option for them to go to jail for a TPO violation. The other side of that is if children are protected parties under the TPO and they're talking to the children, especially using them as pawns, say, "Hey, can you ask your mom about this?" Or does your dad have any new girlfriends? That kind of thing. Because again, I use gender interchangeably here because I've seen women as respondents, women as petitioners, men as respondents, men as petitioners. But again, if they're talking to the children, that's a huge violation of the TPO. And that might be where you want to get the police involved. If there's an open divorce, you would definitely need to tell your guardian ad litem. Um, and there are other, like, again, like calling the police in that situation if there are children might not be the best option, but definitely informing the guardian ad litem would be advantageous.
Related to that, then, is what if, in the reverse, the person against whom you have the TPO ceases and desists, but one of their relatives, maybe their mother, kind of becomes the harasser in their stead? A sister, their girlfriend or boyfriend. Um, what happens then?
That is a little bit of a gray area. It depends if that person is motivated by the respondent and the respondent saying, "Hey, I can't talk to her, but can you act as my agent and talk to her?" But unfortunately, there is not a lot of relief if that relative communicates to the petitioner. The petitioner might have to amend the TPO and include her as a party. But again, that would get more into having a separate TPO towards that person because the court, again, doesn't want to get too extenuated from the two parties. So it's more about protecting the petitioner and her family rather than also enjoining the respondent's family. Um, but if you have any evidence showing that he's like, "Hey, I can't do this, but can you?" He's not allowed to do that, or she's not allowed to do that. So they can't use an agent to communicate to the petitioner.
All right. Well, very good. Um, Caitlin, thank you very much for a very informative presentation.